Hi all, greetings from IIM Calcutta. My name is Rajesh Babu. I'm a faculty at the Public Policy and Management Group at IIM Calcutta. I've been here for more than 14 years. My essential background is regulatory and legal framework. My basic expertise is in the area of international trade, uh, corporate liability, human rights and business. So these are some of the issues that I kind of cover. As part of our engagement with executives, we also offer executive programs, particularly short-term executive programs. And one of the programs that we offer is the contract management and arbitration program, which is a 5-day program for essentially targeting middle management managers, lawyers who are interested in trying to understand some of the basic nuances of contract management. As I was saying, the program that we kind of designed, both of us, Professor Unni and myself, we designed the contract management and arbitration program is essentially to provide participants a comprehensive understanding on the legal issues in commercial transactions with specific focus on contractual issues and commercial dispute resolution. The program shall address different types and facets of contracts and the rights, obligation, and implication of business operations. As we also know that uh, if you look at the index, ease of doing business index in India, you will find that enforcement of contract or the contractual issues, related issues, are one of the important concerns, particularly in the context of ease of doing business. And this program we have specifically designed to ensure that there is preventive mechanism in terms of understanding the nuances of the contract as well as trying to solve the issues even before it goes to litigation. So once we give you a general picture about the general principles of contract, we will get into more specific areas such as government contracts, tender and procurement, bidding processes, involving pre-qualification, request for proposal, bid evaluation, etc. In addition to that, we will also try to cover project finance contracts, various forms of project finance contracts, high leverage, non-recourse finance, BOT projects, etc. And finally, we will end up the program by looking at various dispute resolution mechanisms which can be suitable for amicable settlement of disputes. So this again, the entire aspect of this program, the way we have designed it, is not just about it's not a one-way kind of process that we are looking at. It's based on case laws, based on problem solving, realistic issues, taking up realistic issues, and through analysis of some of the key legal issues that are particularly important from the corporate context. So this is the comprehensive kind of view that we look at from the point of view of this problem. So in addition to providing the general principles of contract, we go into certain specific aspects across when we look at the second day, third day of the program. And that would include, but primarily focusing on government contracts, tender, procurement, bid processes, which is very critical as far as the government contracts are concerned, project finance contracts, and the host of issues that are related to project financing and contract related issues, cyber contract, which has come up in a big way in the recent times. Then finally, we also look at the different methods of settlement of disputes, both domestic disputes as well as international disputes, both win-win scenarios as well as win-lose adversarial kind of mechanisms, so that any entity who are looking at contracts would have a holistic view of how to structure the contract and prevent disputes from arising in the first place.
Hello everyone, I am V.K. Unni. I am a professor with the Public Policy and Management Group of IIM and I also belong to the stream of law, particularly the legal aspects of business, which we have been teaching in all the regular programs, the MBA programs, the MBEX programs, and also some of the doctoral courses. And since 2010 onwards, I along with my colleague Professor Rajesh Babu, we have been doing a lot of training programs in the field of contract management and arbitration for a lot of large industrial entities, especially from the public sector as well as from the private sector. And this particular program on contract management and arbitration has been there at least for the last 6 years as a 5-day module to teach people from the industry. Only during the period when COVID prevented us, we did not have it. As Professor Rajesh was telling, our entire life revolves around contracts, and this particular program, the major objectives are to provide a basic understanding of the various legal aspects of business as well as various contractual dealings, provide a kind of a foundation with respect to commercial contract management, managing the legal risk associated with violation or breach of contracts, addressing some of the major legal issues involved in tendering, procurements, things like project financing, infrastructure contracts, as well as electronic contracts, which we deal on a daily basis. And this course also tries to provide a comprehensive understanding regarding the commercial dispute settlement techniques as well as adjudication, which broadly cover arbitration and other alternative dispute resolutions. So to give a broad overview of the topics which we will be covering, one would be on the general principles of contract. That means the ingredients of a valid contract, concepts like privity of contract, what would be the exceptions which are applicable, breach of contracts, what would be the remedies for breach like damages, liquidated damages, specific performance, quasi contracts, government contracts, some of the special contracts which we deal on a regular basis. Of course, there will be a lot of case laws also, which we will be covering as part of this course. As far as the methodology of the course is concerned, we follow case studies, we discuss a lot of cases so that participants are also actively involved in the entire process of discussions. Then lectures of course will be there, but essentially we try to make it a two-way learning process. Otherwise, on many occasions, like something involving contracts, things can be very monotonous. The methodology of the program primarily revolves around case studies, lectures as well as discussions. We always try to make this program highly interactive. It's not just as a faculty we go and say something, we also highly encourage the participants to be interacting or engaging with us so that the entire process becomes a kind of a dialogue instead of a monologue.